All right, good afternoon, everyone, and welcome to our June installment of In the Boardroom with attorney Andy Phillips and Attolles Law. I'm Sarah Diedrich Kasdorf, Director of Outreach and Member Engagement at the Wisconsin Counties Association, and we are thrilled to host In the Boardroom with our partners at Attolles Law. Today, we have an exciting program for you entitled Damn It, a county's relationship with the DNR and property owners in the upkeep, repair, and conditions of dams. I have just a couple of reminders before I turn the program over to our presenters today. First, if you have any questions during the presentation, please type them into either the chat or the Q&A feature, and we will be monitoring questions throughout the presentation, but may not get to all of them until our formal presentation is over. And second, we will be recording this webinar and placing the recording along with the slides on the WCA website. So you may have noticed by now that although his name is in the title, Andy Phillips is not joining us today. Rather, we have two attorneys from Attolles Law that will be speaking today, Jake Curtis and Rebecca Roker. And since Andy isn't here, and I'm sure he won't be watching the recording, I'm sure it is safe to say that, and maybe I still should be careful here, so maybe I'll just say that we are more than pleased to have Jake and Rebecca joining us today. And Andy, yes, we will get along without you just fine. So with that, I'm going to turn it over to Jake and Rebecca for today's program.
Thanks, Sarah. I'm guessing Andy's probably watching from afar. So I'm assuming among the participants, he's one of them watching. But no, yeah, Andy is out today traveling. So Rebecca and I are happy to be here talking about, I think an important subject. So as many of you have probably noticed, the last few months have been kind of big, more generic topics that we typically cover: public records, ethics, things like that. We thought this month would be a good month to focus on something that's pretty specific, right? Dams and the ownership responsibility that counties have as owners of many dams throughout Wisconsin. There's all sorts of responsibilities that they have as owners. Obviously, a very close relationship with DNR, and Rebecca also served as chief legal counsel at DATCAP. I was at chief legal at DNR. So we have that perspective of kind of seeing this from the perspective of a state agency and really the regulator and the issuer of the permits in these situations. But the reality is counties have a lot of responsibilities when they're in the position of owning dams. And Rebecca, I know you've had a lot of land use experience in your career. And what is your perspective on why this is an important issue?
Yeah, I think certainly there is crossover, oftentimes with land use, real estate, sometimes construction. A lot of our counties have their conservation or other departments that work very closely with DNR are part of their land use and zoning. So I've encountered these issues that way, and I'm sure there's folks out there who've done that as well. But as you mentioned, these are there's so many brackets to these because you have the regulatory perspective from the state's perspective. And then you've got the county responsibilities. So there's lots of different issues that touch each other. So, and you obviously being former chief legal at DNR are the best person to speak on this.
Yeah, no, and I think that those are great points. I mean, there are so many different areas of the law that are impacted when you talk about dams. So today we are going to go through the specifics of the relevant state statute. We'll touch on the administrative code provisions. There's a grant program that we're going to end with, and hopefully if there are counties in a position to maybe consider making improvements or as we'll talk about, one of the options is abandoning a dam. There's a number of options there. But at the end of the day, as you said, it's not just the one relevant state statute, right? There's going to be zoning issues. There's going to be other environmental issues. You even brought up some good points. We'll get into them in a minute. Even some transportation issues that may touch upon this. So it is one of those areas where the law is relatively straightforward, but I think what makes it complex is there are so many other areas that touch on this. And like many policy issues, right, the counties are right in the middle and often have to do a lot of the state's dirty work to kind of address some of these issues. Sorry, just moving on here. So this is our agenda for today. So we're just going to talk briefly about the history of dams in Wisconsin. I mean, frankly, some of it's just interesting. Some important DNR dam facts. A lot of this is drawn straight from the DNR's website. We're going to talk about the legal landscape, and then what I think are some two interesting case studies. We're not really going to get into the specifics because one of them is actually still ongoing, but perfect examples of two county clients that we work with that have done tremendous work navigating a really, really difficult situation with DNR and really trying to get the best outcome for the taxpayers, for the actual resource, right? The water and the land surrounding the dam. And so we'll touch upon those two as really perfect examples of where counties are really caught in the middle.
Right. And the two case studies we'll get to are also excellent examples because they do touch on so many of those different areas that we just mentioned. So it gives folks a good idea of how more complex these can become, even though the law can be straightforward.
Right. So as far as the history, right, so I titled this regulatory history because a lot of this relates to the ability of DNR to regulate dams, identifying who the owner is, and then the obligations the owner has to address what may be issues, weaknesses in the dam structure. So this is I think interesting history for context. So the first dam was built in Wisconsin in 1809. Right, so obviously prior to statehood as a territory, it was already an issue. The first state regulation, these two bullets, I think, kind of lay out how the history from a regulatory standpoint was, to be honest with you, a mess. Right, so the first state regulation of dams began with the Mill Dam Act of 1840. So again, prior to statehood, it was for the purpose of encouraging the construction of mill powering, permitted. This is interesting. It permitted flooding of land of others without acquiring easements. So not really much of a perspective looking at the impact of surrounding landowners, which, as we will see, and as I think Rebecca kind of alluded to, kind of surrounding land rights issues are critical and can sometimes be a huge issue if, for example, there's an abandonment, right? There's going to be a process where individuals can comment. And if the surrounding landowners have a problem with, maybe the devaluation of property, can be a huge issue during a process like that. But then so 1840, right? So we have the Mill Dam Act. 1849 is repealed when the Supreme Court of Wisconsin addressed the constitutionality of preventing compensation for surrounding landowners. But then the Mill Dam Act was revived in 1857, repealed and recreated in 1858. And then the Supreme Court in 1860 would have overruled the act if not for precedent economic benefits. So the point of that is, I mean, it's frankly just interesting history, but just shows how there was this kind of evolution of kind of that regulatory framework where I think the state really in its infancy was struggling with how do we address the regulation of these dams, taking the economic impact of surrounding landowners.
And obviously very important issues still today when we're talking about dams, the economic impact and economic benefits, those are still with us. Is this regulatory background, Jake, is this similar to other areas of the law, such as like railroads or real estate, where we may have an issue or counties may have an issue where we have to go back this far?
That's a good question. And I think actually we'll probably touch on that in our case study, because yes, I think a lot of these issues, obviously, just generally speaking, we're talking environmental issues, historical context is really important, but and I guess we can just kind of preview one of our case studies relates to an ongoing issue where the relevant order is actually a PSC order. So actually we didn't plan that, but great segue.
Yeah, we didn't.
If you look at the regulatory history, so we have kind of this back and forth throughout the mid 19th century. In 1909, right, just from a general policy standpoint, a lot of the regulatory authority was shifted from the Wisconsin legislature to agencies. And so even with respect to the dams and DNR, right, in 1909, that shift took place, and you actually alluded to this, the Railroad Commission, and then ultimately the PSC. So, and in our case study, we'll touch upon this, that actually the relevant order is actually a PSC order.
Interesting.
Which can, asked a good question. These historical issues can really matter. And even in our other kind of case study out of Sauk County, some of the records were looking back to mid 1800s, and there, we'll get into the details, a railroad was really the relevant kind of owner, and then that land was transferred. So I think it's fair to say with a lot of these dam issues, historical records are going to be really key. And so I think that second bullet is important. In 1967, really the creation of DNR, that's when jurisdiction over dams was transferred from the PSC to DNR. And I have the note here because, again, in our little case study, that's really a key point, because essentially you can still have situations like we're dealing with today where a pre-1967 DNR order is really a PSC order that is still not only relevant, it's still essentially active today. And so you may see a situation where pre-1967 orders from either the Railroad Commission or PSC are still active, still controlling, and yet to the extent there's maybe a need for an amendment or an update, the question is, are you maybe amending or updating one provision, or essentially taking an old order and completely updating it to current DNR standards? So again, very much, again, I find the history interesting, but it can be a very relevant piece of a regulatory issue that we're working through.
Right, just how to change one that needs to be changed, but not the rest. Maybe the county doesn't want to change the rest of that order. Interesting.
Yeah, because it really becomes a negotiation with DNR to see, do we want to, you might have a 10-page order, one provision is relevant, but then there may be a negotiation with DNR where do we want to essentially revamp the entire thing to make it consistent with today's DNR standards for orders. And there becomes a legal issue, because by doing so, you may be inserting additional legal requirements pursuant to state statute or administrative code that didn't even exist in those pre-1967 orders.
Cool. Well, and you're the guy to negotiate with DNR too. Lucky to have
I don't
you.
know if DNR would say that. So early 1980s, DNR developed standards for the design, construction, and reconstruction of dams. And then just very generally today, the DNR issues, and we'll get into this, permits for new dam construction. I'd actually be curious if there are folks who have questions or comments, how often counties are thinking about new dam construction. I think, at least in our practice, we often hear from counties that are negotiating or going through a situation with DNR regarding an existing dam. So I'd be curious if there are new dams on the horizon that counties are contemplating. But we're going to be talking about repairs, reconstruction, ownership transfers. Water levels can also be a huge issue, as we'll talk about in our case study, and then the abandonment of a dam. And this is all the DNR website. They have great resources there that you can look to. Just for some more context, some important dam facts. Yeah, those dam facts. The number of dams in the state. So there are approximately 3,900 dams that currently are in existence. There's a cool map on the DNR website that actually shows the location, the status of the dams to the extent it's known, or I should say the condition. So a really cool map to look at. Interesting perspective, us in Southeast Wisconsin, not as many dams, particularly when you look at, I forget which county it was amazing. You look at, Milwaukee County, Ozaukee County, kind of Waukesha, our neck of the woods, there's a handful throughout the entire county. There are some counties, and I forget which one, it was central Wisconsin. I counted, there had to have been at least 60 dams. Wow. So just to put it in perspective, right? So Milwaukee County, I think I counted 3 or 4. And then, like I said, some counties in northern, northwest Wisconsin, 60, 70 dams. So probably fair to say that more of an issue or something of interest for maybe our outstate counties, as opposed to Southeast Wisconsin, where for various reasons there just may not be as many. Interestingly, since the late 19th century, approximately 900 dams have been built, but then washed out or removed. Over 150 dams have been removed from Wisconsin streams since 1960. So a fluctuation. I think this is a fair point to say, when I started researching this and have kind of gone through different case studies looking at them, I think we all think, and Rebecca, you and I were talking about this, I think when we traditionally think of dams, we think of big structures,
A dam.
A dam, right? You picture it in your head. You think that the dam, a concrete structure, very tidy and neat. Well, the reality is there's dozens of different varieties, and not all man-made, right? There can be essentially, and we'll get into this, other structures or other impoundments that can be used for the purpose of essentially holding the water back. And so there's any number of varieties of dams that exist. Interestingly, some dating back to even pre-statehood still may serve a dam function, but have never been actually approved. There's actually a provision in state statute that's going to deal with how do we actually address a dam that's essentially really never gone through an analysis of its condition. And so I think that's an important point to make, that not all these dams are the dams that we necessarily think of.
Do you think there's counties out there that may even have dams or facilities that are dams that they aren't even aware of? Like some of our larger counties, or is now the DNR, do they have an inventory where counties pretty much know what they have?
Good question. I think most of them, there may be some that are still kind of out there that aren't really on any sort of record, so to speak. I think most of them are probably inventoried, but again, another good segue. I think that gets to the point where 60% of the dams in Wisconsin are owned by a company or private individual. So I think, to your point, it's probably possible that there are some dams out there that the condition is still satisfactory. They may not have necessarily been inspected at any point, but are owned by a private individual.
Well, and those private individuals or companies, oftentimes I would think, would come to our county clients and say, hey, even though they may not even realize they own the dam or they're responsible for it, but then they're looking for our folks to help out with it.
Right, and that's a great point. We really don't get into it in this presentation, but there's going to be a role for counties specifically that do have some regulatory authority. We're focusing on kind of the state standpoint, but you're right. It's conceivable that you have county zoning, I'm trying to think what other county departments may actually have some authority, right? So really just a land use generally that maybe asks some of these questions. Conservation, right? And so again, in that context of private individual, 9% of them, of the dams in the state are owned by the state. I thought this was a pretty high number, 17% by a municipality. And so municipality is defined broadly under Chapter 31 to include towns, villages, cities, and counties.
Okay.
And then 14% by other ownership types. Just an interesting jurisdictional point, right? The federal government, the Army Corps of Engineers is going to have some regulatory authority with respect to some of these dams. So there is some overlap between the state and the feds on some of these issues. And so there's kind of something important to keep in mind. So this is a good point at which we'll probably jump into the comments here. No comments just yet. Reminder, if you have questions, comments, please, we're going to monitor the chat here. So please fire away. It's good for us to see if there's questions or comments or things that people want addressed. So we've talked about the legal landscape. Let's start. And this is just so everybody knows, we're in Chapter 31. The nice, some areas of the law, you're going to have to reference 10 different chapters, a lot of different case law. There is case law in this area, so I don't want to suggest that you can't look to that. But here, we're really almost exclusively in Chapter 31. When you're talking about water levels and things like that, there's going to be other relevant DNR chapters of the state statutes that are applicable. But when you're talking about dams specifically, you're going to want to definitely start with 31, and most of your answers are going to be there. So we thought it was important to start with just the powers and the duties of the department. So the department is going to look at public rights in navigable waters. So I didn't have it in here, but the public trust doctrine is going to be relevant from a constitutional standpoint because we're talking about navigable waters. They're going to be looking at promoting safety and to protect health, life, health, property values, and economic values. I think you and I agreed, and we wanted to really touch on that. Not that that's more important than life, health, or property. I think when we traditionally think of the police powers, right? We're thinking about life, health, property. But here, and again, this is directly from 3102. Here, we're also factoring in from a statutory standpoint the impact of these dams and any revisions we may make or DNR may make to the permits relating to a dam, what the impact on property values and just generally economic value is going to be. I know you had some good thoughts on that.
Well, and given the makeup of ownership too, not only do we have a large number of individuals or private companies owning these dams, so regulation is obviously going to impact those owners, but the folks that are, whether it be owners on a lake whose water levels are impacted. I know that's part of our case study. But yeah, I do think it's interesting that the statute specifically calls out economic value, because oftentimes when we're talking about that, the constitutional analysis or a takings analysis or a proper use of police power, yes, economics do come into it, but just as you mentioned, it's usually health, welfare, and safety. Here we have a statute that specifically calls those two, the values and the property and economic values, which I think is interesting and brings that, the economic factor right up to the forefront in our discussion.
Well, and even, to put a finer point on that, you're right that we all know the reality of the situations where if you have a dam that's impounded water for 100 years, right, and there's been economic growth around that, that economic growth is going to typically include homes, vacation properties, and things like that are specifically built around this body of water. And we all know here in Wisconsin, we love our lakes. And so those property that you and I were talking beforehand, you compare a property off water in northern Wisconsin with property on water, and sometimes you're literally talking 400% or 500% increase of property value just to be on a really nice body of water. And so when you have these adjustments to or improvements that need to be made to a dam, to the extent there's any impact on that water level, you can be talking about significant impact, economic impacts, property values. And so again, and we'll have this case study without getting into really the specifics, how the county can find itself right in the middle of all this.
Yeah, I mean, take that to another level too. When we start talking about adjustments in property values, now we're talking about obviously property taxes and assessments and all of the relationships between, the counties and all of the other municipalities and property tax collection. We've seen some of those types of legal issues cross our desk recently too.
Actually, I hadn't thought of that. That is a tremendous point where, if you have county finances that are based on essentially tourism or vacation properties, and you have an impact to a resource like a lake, and that significantly, let's say, has a negative impact on the surrounding property values, you can be significantly impacting county finances. So yeah, great point. And again, this is not an opinion of ours, and this is baked right into the state statute. And so going on, because I think this is important to really, this is like the foundation of what the DNR is going to look at when they're addressing any number of these options. And we kind of touched upon this, right? So they're going to regulate and control the level and flow of water in those navigable waters. So you're going to address things like the maximum level of water that can be impounded, but then also the lowest level of water that needs to be maintained by a dam. We've highlighted the gauging stations. And again, we want to make sure we get through everything here, but this is just really important stuff. In our experience, and I know Rebecca and I were talking beforehand, had some real world examples of like literally whether it's water in a gauging station, or I know I personally had some situations where it was air quality issues and the air monitors. Just the physical placement of these gauges or monitors can have a significant impact. So when you're looking at establishing and maintaining gauging stations that are then used to monitor or I should say establish, right, the max and the min levels of waters, where you
Where
physically
do you
place
put
that gauge can be huge.
Right. And as we look at, counties' responsibilities to make decisions based on facts and data-driven decisions, those are obviously important elements in any decision. Well, that data that we're obtaining, how did we get it?
Right.
Is it valid data if we put the gauge in the wrong place, or, what are the variables? So I thought that was a really interesting component. And then what do you do if, in your example, the regulatory body puts it in a place that's not proper,
Right.
that doesn't allow a county to make the best data-driven decisions?
I mean, the story I can share, because it's now it's a closed matter. It actually was on the air side, and so you had an issue with eastern Wisconsin county that had air quality issues, and the EPA was applying essentially a non-attainment zone status to this county, which has huge impacts on manufacturing and things like that. And what the debate came down to is essentially where the air gauge was placed. By placing it on essentially on the shoreline with Lake Michigan, it was significantly impacted by not only southern Wisconsin issues, but even Illinois. And
Chicago.
Blame it on Illinois. But by moving that air monitor a few miles to the west, significantly changed air quality. And now, obviously, if the air quality is poor in one area versus the other, I mean, that's a discussion that needs to be had, right?
Mm-hmm.
I mean, we don't just ignore the fact that maybe air quality is worse in a different area. But even as you alluded to, right, with air quality today and yesterday, right, it really still depends on where you're at.
Mm-hmm.
But from a regulatory standpoint, either you got to place that gauge or that monitor in a compromised position, or you may have to have multiples, right, and then have an average. But sometimes it's as simple as where we're placing that gauge or monitor can have a huge impact on whether or not you're ultimately meeting those requirements under the order, right? Because ultimately, all this gets down to is the maximum and the lowest level of waters pursuant to the order.
Mm-hmm.
Well, to your point, how do we establish that? And so where we place this gauge becomes really key.
And another point where we have a very straightforward statute that should be easily applicable, but now we get into a negotiation with DNR as to where to put it. So even though we have a nice clean statute, there's still room for interpretation and negotiation.
Yep. So two questions. One relating to the 17% number, as far as do we know how many specifically are under the oversight authority of a county? Good question, Cameron. I'd have to dig in to see those numbers. So again, 17% is defined under Chapter 31 to include basically every local unit of government, town, village, city, and county. I can say from my experience, there's a lot of county-owned dams. So again, of what percentage of that 17% is made up of counties? I don't know exactly. I just know, like I said, just anecdotally in my experience, and we'll see if we can dig that up. But counties certainly are in a critical position of owning, if not numerically, a lot of the dams, some very critically, geographically located, critically important dams.
Mm-hmm.
Just off the top of my head, I can think of a number of examples, several of our county clients that are really in the thick of it, having to negotiate with DNR. And so again, I don't know what it is. I just know counties are often at the forefront of these.
Okay. Yeah, I don't know either, but the issues I've encountered have all been with respect to the counties.
And I think maybe it's probably fair to say that because, as you pointed out earlier, there's so many other issues that maybe when the county is involved, it's maybe elevated, right? Because you're going to have any number of other land use issues, real estate issues that a county is going to have to navigate. The second question, I'll be honest. So it's, will Wisconsin allow tailing dams, and how would the safety be controlled? Dave, great question. I don't know the answer to that. I know, like I mentioned earlier, there are a number of different varieties of dams, right? When I first started dealing with these issues a few years ago, if you would have told me a dam, I would have immediately thought of a very traditional structure, and have learned though that there are any number of varieties. In my experience, I can tell you the folks over at DNR that are responsible for this area are very willing to to talk to you. So if that's a specific question that you have, I would encourage you, we can certainly help with this. I would encourage you just to look at the DNR web page on dams. There's a great series of websites that they have, and see if that's something that the DNR will be looking at.
Good questions.
So this is just kind of a quick summary of what we talked about earlier. So when kind of the scope of what we're looking at, we're looking at new dams, repairing or reconstructing an existing dam, raising the actual height or enlarging the width of an existing dam, transferring ownership, removal, and then altering the water level being held by a dam. So we'll start and we'll try to get through these so we can leave time at the end for questions. As far as constructing a new dam, again, I'm frankly curious if there are counties out there that are considering this. But if you are, there's a very specific process you're going to have to follow under 3105. And really, you're going to see a theme here with all these. And frankly, I can summarize the next probably 10 to 15 slides where any action you're contemplating, there's going to be a process that you have to follow with DNR. There's going to have to, in most of the cases, be notice giving out so that adjacent property owners, other interested parties will have the ability to weigh in, and then ultimately a hearing. So with respect to constructing a new dam, there's going to be a hearing. I thought kind of the analysis or the steps that DNR goes through is kind of interesting. So, and I'll just kind of go through this last one. In considering public rights to the recreational use and natural scenic beauty of a river, the department must, it's a shall, they're going to investigate the potentialities of the lake and lakeshore created by the flowage. And then they need to weigh that recreational use and scenic beauty of what will be the lake and lakeshore. They're weighing that against the known recreational use and scenic beauty of the river in its natural state.
That's a lot of subjective factual analysis.
And I think that's absolutely the most important takeaway there. Okay, everybody can read. Seems rather straightforward. This would be the type of situation where if you are considering kind of weighing in and getting involved in a new dam, you're going to really want to dig into the decisions that DNR has made. Because as we sit here right now, right, that's a statutory language. How's it been applied? That's where, when we talk about case law, and to the extent you can get the administrative decisions from the DNR to actually look at, what are the factors that they're going to use. And this is where the administrative code could be helpful, but I think even there it's maybe limited, where you're going to want to see how's this actually been applied by DNR. How many cases have they looked at where they've said, well, we think there's a benefit, a recreational use to this new lake or lake shore, of weighing that against the current use and scenic beauty of the river. And again, I'm just guessing, but maybe it might be more often than not the river benefits outweigh this potential new lake.
Particularly if that new lake is proposed by a specific developer, a specific person, and we look at, public benefit. Is the public benefit of this new thing, how wide is it versus the public benefit of the existing river? Right.
And then, to that point, it's not, I think this third bullet is important in that, again, this is straight from 3105 and 3106, is that it's not just that section of river. As we all know, right, and if you have a river and you impound at one point, there is, we say upstream impacts, right? Here we're talking literally about upriver, upstream impacts to how one impoundment in one section of the river is going to impact other sections. So that's, again, from a very foundational standpoint, I think important to understand how DNR is going to approach these issues. So again, we're still looking at new dams. The department is going to deny, and this is essentially the same thing, right? So they're going to look at the factors we just talked about and weighing that new lake shore versus existing river. They're going to deny if looking at the natural state that there's just simply better recreational scenic value for a larger number of people with the river or stream as it currently exists versus what could occur.
Well, we as lawyers love to argue, facts and points. I mean, even just that requirement of what is natural state? I mean, I'm sure that, we could have a long discussion of what is a natural state. So it's striking to me how a very straightforward statute still includes all of these provisions that are really very subjective.
And I was just gonna say, you used the word before, I think it's the right word. This is very subjective. Now, again, it's not, in fairness to DNR, it's not, them just sticking their finger in
Right.
the wind. I mean, they're gonna go through a series of factors, but again, if this is the language. I mean, this is essentially a copy and paste of the language to try to organize it so everybody can read it, but we haven't really put in any commentary. So if you're DNR and this is the statutory framework you're going through, this is where, again, precedent becomes important. Because, I mean, yes, it's subjective language, so the question is, how has DNR subjectively applied it? And so that's where, we can help, or your corp counsel can help actually go through the analysis.
Can I ask another question here? And maybe it's better to wait for our case studies. But how, in your experience, how much does DNR take into consideration local input? So, a county's input as to what the natural state should be, what the county's input as to the economic benefits, all of those points. And again, and just in your experience, do the DNR give deference to the local municipalities and counties, or is it, in your experience, more, nope, these are what our standards are, these are what our factors are, and thank you very much for your input, but we're going to make our own decision?
Good question.
Sorry, I didn't mean to stump you.
No, I'm just kind of thinking, I think the reality is DNR, again, I was there, people like to beat up on DNR, and sometimes, I may disagree with some of their decisions, but at the end of the day, I think they do try to take into consideration, in particular, whatever municipality is a relevant municipality. I think on a lot of these issues, it tends to be the counties or the towns. I think, in my experience, they're going to, they might not add additional weight or give additional weight to a county position, but they're certainly going to maybe take additional time to hear the county's position. In the matters I've dealt with, I think there were very good faith negotiations. Again, even when we disagreed with the outcome, it's not like we weren't given opportunity. And so there clearly, from a statutory standpoint, is a focus on the owner. And so to the extent the county is the owner, I mean, that is going to be a very direct kind of line of communication. And I think, adjacent towns in that situation are going to be given a lot of voice to have a voice at the table, so to speak. So good question. And I think, in fairness, I think the counties have a significant role. I think it's really interesting. So our good friend Matt from Sauk County just has chimed in and said that Sauk County has approximately 180 dams within the county, and Sauk County owns 6 of them. So I think that it's kind of a surprising number. So maybe,
180.
yeah, so maybe ownership is maybe more on the munis, so towns, villages, cities.
Yeah.
But there again, I think Matt would probably agree that the counties, for the 6 they own, are really significant from a resource standpoint. Not to say that the other ones aren't, but that's interesting. So that, as if that's applied to that 17%, then the county would maybe not be in the majority.
But it just seems like, in my experience, and I think in your experience, that even if it's not a county-owned dam, counties are so often brought into the discussion.
Yes.
For one reason or another, for all of those other, topics that we talked on where there's crossover. So even if Sauk only owns 6 of them, they may have been brought into other situations.
And wow, we have you are getting perfect segues here, because
And
now,
I'm not doing that.
yeah, this was not planned. And
No.
another
See,
great
Andy never has to do this
Andy,
again.
yeah, we don't need
Sorry,
Andy.
Andy.
If you're listening, you can stay away.
But we won't keep him away, because I'm sure all of our
Yeah,
viewers love Andy. We'll
That's
never
true.
replace Andy.
Dave has a good question to the point you just made. So in the rural area of a dam, what is considered the actual municipality? So yeah, there can be situations where there's maybe some ambiguity as far as who the interested parties are. So you may have, for example, town ownership of a dam, but then let's say there's a county park. We talked about kind of the different sections of a river, right? So you may have a situation where the actual owner is a town, and they're going to be the party that is essentially the permit holder and the permittee. And so the permittor, the DNR, they're going to be the ones having the direct communications and negotiations. But in that scenario, the county, if let's say downstream, upstream, whatever the case may be, there's a county park. Well, the county is going to have a significant voice at that table. Or you may have a situation where the town owns the dam, but upriver, upstream, there's significant, vacation homes, whatever the case may be. Those residents are going to probably complain to the county if they're not satisfied with the outcome. So that's where things can get really, I think, difficult.
Yep.
And so I think that the question is, Dave, the answer to your question is, it's always going to be clear who the owner is.
And that's the key.
That's the key.
The deed is going to tell us who the owner is. So you may even have a situation where a town or any, is the owner of record based on the deed, but that's not even in the town anymore, right?
Well, yeah, you could have a situation like that. I mean, for me, I would start with, so this is where the real estate may get mixed in with the regulatory side. If I were in a situation like this, where there's maybe a question over ownership, things like that, I would just look at who holds the permit.
Oh, okay.
So, I mean, there's physically going to be an order or a permit that's been issued by DNR, or again, if we're talking pre-1967 PSC, like in one of our case studies, it's actually a PSC order that's relevant. Like that's where I would start.
Okay.
Like,
So-
who did DNR actually negotiate with and, provide conditions to? And it's literally just gonna be a piece of paper.
So you could have a situation where the permit holder is not the same as what appears on the deed, though. And then that, I would think, opens up a whole other
Yeah.
can of worms.
That would absolutely be a can of worms.
Okay.
And yes.
I don't want to get too far into the weeds for you. but-
Yeah,
See, this is all the interest, the stuff that,
yeah.
we legal dorks kind of
Yeah, no.
find really interesting.
I think it's conceivable, in my experience, though, we're just gonna start with who's got the permit, or
Okay.
who's got the order.
Good.
And from that standpoint, you're gonna kind of, starting from there, work forward to see kind of what conditions have been placed on it, the improvements that need to be made.
Cool.
So we're gonna try to get through this. It's a great discussion, good questions, and this is usually what happens is
Yeah,
we end
keep
up
the
not getting-
questions coming too.
not getting through all this, but that's fine. So raising or enlarging existing dams. I'm gonna go through these next slides pretty quickly, because again, we spent those two slides talking about constructing a new dam. Well, you can raise an existing dam, you can enlarge or widen an existing dam. Same process, right? You're gonna have an application, you're gonna have to go to DNR. I'm emphasizing, right? So any sort of, again, raising, enlarging, to the extent there's an impact on property rights, you're gonna want to take that into consideration. So that's 3113. What are the obligations? So you're an owner, right? So you own a dam. What are your obligations? These are the factors you're going to have to go through. You need to be looking at protecting public rights in the waters, preserving life, liberty, health, property. You cannot willfully or otherwise injure, remove, or destroy. And except in emergency situations, again, you're requiring protection of life, health, and property, and you can't be making a substantial alteration or addition that's not going to take those factors into consideration. So this is kind of a good summary of really the factors we've been talking about from a DNR standpoint. Okay, now this is the situation where you're the owner. What are your obligations? I really wanted to get to this because this, in my opinion, the inspections is really kind of the flashpoint. So we've established, okay, what are the authorities and powers of DNR? What are your obligations as an owner? Okay, so we're talking about structures you own and you're continuing to maintain. The big flashpoint, in my opinion, is when these inspections occur. So there's three kind of important categories. You have high hazard dams, and there where there's a probability that there's going to be a loss of human life. So high hazard, right? That's going to be your highest. Low hazard are large dams, the failure of which would probably not cause significant property damage or loss of human life. So it makes sense, low hazard. And then you have kind of the in-between, significant hazard dams. And I should point out, these are all large dams, which then we define here from 3119. You have two kind of categories, 25 feet or more impounding 15 acres, or 6 feet, or more than 6 feet impounding 50 acres. So all three of these are large, but high hazard, low hazard, and then significant hazard. So that's a large dam, the failure of which would probably cause significant property damage, but not human life. Okay, so what does that mean? Well, it's important because any county that owns a dam knows kind of what these obligations are. So first, it's important to realize or recognize that DNR can inspect on its own. We'll get to that. They really have that authority, but at least once every 10 years, they're going to be inspecting high hazard and significant hazard dams. So important, right? So that doesn't exist for low hazard, high hazard and significant hazard. But for inspection,
they make those determinations though, right? And something could go from low hazard to high hazard or significant hazard, right?
Great question.
circumstances.
Yeah, I think, and frankly, I'd be curious if there are folks on who are listening that have a perspective here. I vaguely recall, and I can't remember, I think it might have been when I was at DNR, that there was a negotiation as to whether or not something was high versus significant.
Again, lots of facts.
Right, I
very
think it would be very
subjective.
fact specific but I think for the most part, right, I mean, as the regulator, DNR is gonna ultimately have the authority to make that determination. But, you know, to your earlier point, I think they would take into consideration points raised by the owner. But that first bullet, right, inspection by the DNR. Second bullet, inspection by the owner. So within that 10-year period, there are still going to be obligations of the owner to engage a professional engineer that's recognized under 443 of the Wisconsin state statutes. So if it's a high hazard dam, within that 10-year period, you have to have an engineer inspect 4 times. Significant hazard is going to be 2 times. And then an owner of a low hazard has to go through that process at least once every 10 years. Okay, so, and I think that's an important distinction where there's not going to be inspection by DNR, but at least once every 10 years, you're going to have to engage that engineer. You take that report then, and then within 90 days, you submit the report to the DNR, which kind of shows the results of the inspection. If there's any issues, you actually have to go through kind of what the plan is to address them.
Sounds expensive too for counties.
I think it's fair to say it can be expensive, right? And so hopefully if you are a dam owner, that you have a process in place and have a good relationship with the engineer that you can go through this. So, right, so what are some other factors? There's a complaint process where the DNR will do an inspection if they receive a complaint from the mayor of a city, supervisor of a town, or the president or trustee of the village. No county.
I was gonna say, I know.
No role for the county.
Who's missing there?
Yeah.
And why do you think that is? And how could a county get itself, and could a county conceivably make its voice known at this point? We're in the process.
Yeah, my gut tells me that if you are a county and you observe a significant issue that can impact health, safety, property values, all the factors that we've been talking about. I mean, I gotta think a county could send a communication to DNR that there's concerns with respect to a dam within the county that may not be owned by the county, but they still have concerns with, and they have to think DNR is going to, I mean, maybe from a technical standpoint, that it's not gonna trigger a review under this section of state statute, but again, DNR essentially has the authority to do it on its own. So it would be no different than maybe just a concerned property owner,
Right.
Making a complaint and raising concerns with the DNR.
And it goes to our police power.
Right.
The county's over.
Well,
police
actually,
power.
now I did it. The segue into the second point, discretionary inspection. So right, pursuant to state statute, the DNR can inspect or cause inspection to be made of any dam. Right, so they can do it on their own. So these are inspections. We're running out of time here, and I want to make sure we have enough time for questions. But
The abandoning.
I think it's fair to say that if you take something away from the presentations, in fact, these inspections are really critical. I mean, they're required. So if you're a dam owner, you have to do it. But also, it's kind of, again, I call it flashpoint, trigger point, whatever you want to call it. But right, with the number of dams, maybe a quick aside here. Both Rebecca and I have been at a state agency. The reality is Wisconsin's a big state, and you were at DATCAP. I was at DNR,
DOT.
right? And you were at DOT, right? There's a lot of square miles in the state of Wisconsin, and a lot of it is not necessarily under the watchful eye of a state bureaucrat. And so at the end of the day, a lot of the issues that we're going to be dealing with are going to be triggered by these
Absolutely.
inspections,
Absolutely.
where an issue may be lying for a few years, an inspection takes place, a problem is identified. Well, now we have an issue, and DNR, because you're seeing a lot of shallows, right? They don't really even have discretion in some of these situations. If there's an issue pursuant to an inspection report, they have to take action. And so that's I think where a lot of these issues come to the front. Quick question. Just some more good comments from Sauk County, and we'll get to Sauk in a second, hopefully, because they've kind of have a war story, so to speak. So we've been talking about, again, processes, owning, inspections. Well, now, so what are some of the options? So hopefully in the next 5 minutes here, we can get through some of the options quickly. So a dam can be abandoned. I'm not going to read through all this. I think the point is, again, there's a notice requirement. I think that point should be obvious, but to the extent you're in a position where you're owning a dam, really any action you're going to take requires, again, you want to, it's an order or permit. So any action you're going to take is require notice to DNR that they can review that. Oftentimes pursuant to state statute, they have to do an investigation and then ultimately approve whatever action you're contemplating taking. Here, with respect to abandoning a property, a dam, there's specifically going to be a hearing. And so this is where, again, you made the point several times now, how important kind of adjacent property owners are. It's not a cosmetic thing. They're important because to the extent, so for example, if you're abandoning a dam, there's going to be a process whereby they can make comment, testify for or against the abandonment of a dam at a formal hearing held by DNR. And so, I mean, they play a critical role.
And that's where we make our record too. Not only the property owners, but the county input or other municipal input. You're creating a record in case you need to ultimately challenge whatever that DNR hearing or that DNR determination is.
Right, exactly. You can transfer a permit. Same thing. You must submit a request in writing. There's going to be various kind of factors that DNR is going to go through. Interestingly, no permit can be transferred aside to a foreign corporation. And so that's where you get maybe some of the current policy debates that could impact whether or not you can transfer a permit to a foreign corporation. But so that's kind of option 2 for you have an existing dam. What can you do? You can abandon it. You can transfer the permit.
And that one I think is really interesting too, as we see new development across the state. There may be an opportunity for a developer to propose taking over the dam if it is involved in that development piece. And then it relieves a county or another governmental entity from the responsibility. But how do you do that? How do you've got private company or individual who's willing to take it on as part of their new development, but how exactly do you do that? And to what extent can we ensure that does happen or doesn't happen?
Right.
So
yeah,
again, just another touch of different areas where factors become very important.
So we've talked about abandoning. You can transfer the permit. And then I think that the major last category here is removing a dam. And I think this is probably the one that we hear most often as far as kind of a negotiation with DNR. So this is straight from DNR's website. Just kind of generally speaking, several major issues can lead to dams needing to be removed. So we talked about inspections, major point here, right? So the removal of an unsafe structure under 3119 is oftentimes going to occur after an inspection, right? So the owner does the inspection, submits that report to DNR, and there are significant problems. And Rebecca and I talked about this beforehand. We're not experts, probably like some of the folks on this meeting are. The reality is cost becomes a huge factor, right? So if you're a county, you own, and you just went through an inspection and you see millions of dollars of repairs that need to be made, and it's not really discretionary. DNR is going to say you have to make these repairs. Now you have, and you've talked about the financial impact of some of this. If you're a county and you're the county board and you have to make this decision along with your administration team, like, what do you do?
What do you do?
I mean, this is the perfect policy question. And this is why, as Andy would say, all you folks get the big bucks, because you have to make the tough decision of, do we dump in millions of dollars to this structure? And there may be reasons to do that.
Mhm.
I mean, if you have the structure that's, again, impounding a 500-acre lake that has multiple $1-million homes, which, to your point earlier, is a significant base for property taxes,
Mhm.
it may make sense to do that. If it's a dam that's maybe not really a significant economic driver, right? There's not really an impact on the resource. It just may not make sense to go through those improvements.
Or
So
serves
that-
one or just a few properties. We've seen that before.
Right. So in that situation, it may make sense from an economic standpoint, from a resource standpoint, to remove the dam.
Mhm.
There's a second point that relates kind of specifically removing abandoned dams. So, right, we talked about abandoning. Well, then once it's abandoned, then it can be removed. There are significant environmental impacts. Those are typically going to be, I guess it's possible a county could go through the analysis, but they're typically going to be dams actually owned by the state.
Okay.
And then a little bit of a nuance here, but a dam was not authorized prior to construction, and no entity is essentially willing to be responsible, right? So in that situation, DNR may decide to remove it. And so, just quickly going through this, under Chapter 31, this is very general language, right? So if we look here, that's really the last point on removing a dam. I would argue pretty general language. The reality is, as you pointed out, very fact specific, right? So this is a reference right in 31-253. There's a reference to Chapter 227, specifically saying this hearing may not be converted or treated as a contested case hearing, which you and I are very familiar with as kind of essentially that pseudo trial that's going to be done with an administrative law judge, not as formal as a circuit court hearing, but pretty formal. And while it's saying it may not be converted, I think it's important language suggesting that these hearings are pretty formal and pretty significant when you're going through the process of removing a dam. It's going to be very fact intensive. A significant informational hearing is going to take place. And so while this is pretty general language, I think the reality is we know that these can be very contentious, very time consuming, very costly. But again, it still those costs may be outweighed by the reality of what it's going to cost to repair a dam.
Right.
So we're just going to try to get through. We don't have a lot of time. These are the relevant administrative codes. So make sure that when you're looking through these, when you're looking through Chapter 31, don't forget about the administrative code. Just a quick plug that there are two grant programs. So there's a municipal dam grant and then the dam removal grant. The reality is, if you look at the dollar amounts, because you can't receive a grant from both programs. Municipal dam grant is significant. So if you look specifically at dam abandonment and removal, that can cover 100% of the first $1 million of eligible project costs. So a huge project, obviously, as we all know, right? There's a statutory framework as far as how much they're willing to pay, how much is actually funded. It's a whole different question. I've seen the number 10 million in some of the DNR sources that I've looked at. So not insignificant. That means maybe in a given year, you could possibly have 10 different projects that the DNR says, hey, these are really important dams that we think need to be removed to maybe improve the resource. And so not an insignificant number.
And again, negotiation with DNR in terms of how much the grant is,
Right.
correct?
Yes. So good point. I mean, it's, this is a range. And so in my experience, I've been involved in a lot of these, but in a few of the ones that I've seen, DNR will maybe look at the funding that's available and work with the owner to say, maybe it's 100,000, right? We have 100,000, we can help you with this on this project. So two quick case studies, and we'll just get through these quickly. I know we know we have some folks from Sauk County. They did a tremendous job working through a very difficult situation. The Hemlock Dam, located in Sauk County. Really, I pulled this image, but it's not the greatest image, but if you kind of look in the middle, that's essentially the dam, the Hemlock Dam structure. That's the impounded water. What's significant here is there's actually this trail, the state trail. It used to be a railroad trail, railroad tracks. that then was converted to a state trail. The significance here is there was a long negotiation between Sauk County and DNR because there was a debate as to kind of this role of the trail and actually serving as a part of the Hemlock Dam. And again, I won't get into all the details, but Sauk County did a tremendous job working through a very difficult situation. The other point I would make is just to show you how complex this would be. There was actually a we call it fiber optic line, right? As if Sauk County didn't have enough issues to deal with. There's a fiber optic line that was essentially lying across or near the trail and near the dam. So I think just the point here is it could be very complex. To your point about kind of the relationship between the state and the county, I think it was a good dialogue, and the county had to work really hard to get a good outcome. But at the end of the day, these can be really complex and require a lot of time and expenses. The other one I really won't get into much detail on all because this is still very much a live issue. But Sawyer County is doing a great job dealing with an issue on the Billy Boy Dam. The only point I want to make there is the fact that when you have a dam, it's important to keep in mind that we've been thinking a very simple situation. A dam on a river that's created a lake. Well, you can have dams on a lake that's part of a chain. And you're talking potentially impact across the entire chain of lakes. And there I would also note, without getting into too many details, the placement of the gauge can be really significant. So when you look at a situation like this, we have a dam impounding water that's impacting a chain of lakes. Where you place that gauge and on which lake can be game changing to the debate. So that's all I'll say on that one. But just, Sawyer County is doing a great job, and that is a very difficult situation, very complex with a chain of lakes, placement of a gauge on different lakes, different locations on different lakes. So really tough situation.
And we've got such great resources in our state that, in terms of natural resources that are chains of lakes, we've got them all over. So, even if that one is in Sawyer County, I can imagine that other counties face that as well.
So unfortunately, we don't have, we're happy to stay if they're.
Question about decommissioning.
So we have one question: is decommissioning a dam the same thing as removing a dam? I think that may, I think they are. I'd be curious if others have a different view. That may just be a term of art, but.
Well, I think it also goes to the operation of the dam. So if you're decommissioning, you're taking it out of service. So the structure itself may still be there. And you're not actually removing the physical structure, because that can create problems, because even if it's decommissioned, even if it's not operational, is the county still obligated to fix it?
And I guess when I think of removing under Chapter 31, I'm viewing it kind of through the lens of the structures actually being removed. And that's why you're looking at things like the impact, right? So if you've had a river then there's the placement of a dam, whatever, 100 years ago, and then you have this impounded body of water when the actual physical structure is removed. So not just decommissioned, to your point, but actually removed. You're obviously right. You're no longer damming up the water. There's a huge impact on that whole resource. And so, I like how you put that. There probably is a distinction from a legal standpoint, though. We're looking at actually removing the structure. Another quick question.
Should I read it? Is it the DNR's responsibility to notify owners of low hazard dams when they need inspections every 10 years? That's a great question. I actually thought of that. Is what if I'm a property owner, I may not know that I have this obligation. So does DNR send out reminders? Are they obligated to notify?
Yeah,
does that somehow fall to a county?
Yeah, good question. I think I'll answer it by saying I'm not sure if it's DNR's responsibility, but I certainly wouldn't rely on it, right? So if you're going to be now, it's important, right? So there's Thomas specifically referencing low hazard dams. So there's the three categories, but they're all large within the overall category of a large dam. So we're talking, pretty significant structures, right? 6 feet impounding 50 acres or more, or is it 25 impounding probably 10 acres or more, right? But in other words, I mean, right, these are significant, large, legally speaking, large dams. And so I guess, I don't know if the DNR has a responsibility. I think it would be important as the dam owner to know kind of what time frame you're on. In my experience, at least the counties that are in the position of owning a dam, they have a good record keeping system. And in fact, they're going to be keeping, yearly, monthly, so I've seen some of our clients keeping weekly records as far as water levels and things like that. So, I mean, I guess the point there would be embrace the responsibility, because frankly, by doing so, I think you're going to avoid problems down the road. So, I mean, I'd have to look specifically how the state statute's drafted, but I mean, at the end of the day, if you have a large dam, even if it's low hazard, you want to be making sure that you're meeting those inspection requirements, because again, it's got to be a recognized engineer going through that inspection.
Great question.
I don't see any other questions. If people have questions, please feel free. Our email is here. Feel free to shoot us an email. Again, we've been able to work with some great county clients that have navigated really, really difficult situations. And
No pun intended.
Yeah, thank you, Mike. I did not intend that. But they've done a great job because this is really complex. You have legal issues, you have political issues, you have resource issues, and so if you're dealing with this, work with your corp counsel. And if your corp counsel has questions or concerns, we're happy to talk them through with you. And so, and obviously a thanks to WCA for being willing to focus on what may seem like an obscure issue, but in our experience, we're dealing with this a lot more. And I don't know why that is. I don't know if there's maybe a change in kind of how the DNR is approaching this, but a lot of counties who own dams have been having issues that they're trying to navigate.
And the financial impacts too. In my experience, that's been a big part of it.
Huge. Yeah.
All right. And so thank you so much, Jake and Rebecca. And before we close out today, again, I want to thank you for your outstanding presentation. Some great information. You guys had some great discussion. I love the banter back and forth. Gave us certainly a lot of food for thought on this issue. And also to our county officials, I want to thank those of you that joined us for today's webinar. And again, as a reminder, the PowerPoint and recording will be on our website early next week. And we hope to see everyone back on July 26th for our next In the Boardroom, where we will tackle the sale of lands taken by tax deed in the Tyler versus Hennepin County decision. Again, thanks for joining us today and have a great 4th of July weekend.